My name is Sheldon McLeod, and this is Thinking Out Loud, and it is presented to you here exclusively by the Saltwire Network. And it was a really big day for a couple of reasons, one of which was this court case. Steve Bruce with the Chronicle Herald, here posted at saltwire.com. Lisa Banfield prepared to tell story to Mass Casualty Commission, says her lawyer. And this had to do with what was described as a jeopardy. She was facing a criminal charge for allegedly providing ammunition, she and two others, to the gunman. Of course, the Crown has always maintained that there's no evidence to say she knew about this ahead of time. But today, the Mass Casualty Commission heard two things. One was a foundational document outlining what was described as overnight in Debert, where the killer spent the night. The evidence was presented, and then lawyers got up and for representing the family to offer some clarifications, some questions. But then after a bit of a break, the commission chair came back to say why they will be calling some witnesses moving forward in the next phase after the presentation of the three foundational documents. All of this, it sounds complicated, but it was a really big day in the commission. And Adam Rogers, as mentioned, is a lawyer who's worked with the Desmond Inquiry. He has been watching this and has been providing his own commentary on his own YouTube channel. Adam Rogers, welcome back. Thank you for this.
Thanks for having me on, Sheldon.
Curious to your reaction. The commission chair, Mr. McDonald, said in no abject terms that they did not need any convincing to know that Lisa Banfield's testimony is going to be critical to this process. What did you think this morning?
Well, it was a really pivotal day in that regard. We've been wondering, the family's certainly been wondering, many in the public, whether there would be any witnesses called, and in particular about Miss Banfield, of course, with her central role in all of this and her knowledge of the gunman and everything else. So it was important for us, I think, really to get a sense, maybe for the first time, how the commissioners are going to address this issue of being trauma informed. You know, there was some concern that would mean no witnesses or very limited witnesses. And today we've heard that they'll be calling most of the witnesses that were requested. So it was very important in that regard, and nice for me personally too, because I'd put out a piece not long ago suggesting what trauma informed should mean for this inquiry, and it was consistent with what Chief Justice McDonald outlined this afternoon.
Former Chief Justice, only clarifying that because of this is people are very hypersensitive over language and very much interested in knowing the people involved. And this man, this former Chief Justice, has had a reputation. He's had a career. Some folks were worried that perhaps the process itself might overwhelm a crisis of integrity. That was the narrative last week. Right. Are we any closer to showing at least the appearance and a modeling of transparency here?
I believe so. You know, with the commission saying, yes, we're going to hear from witnesses, lawyers will have the opportunity to question them. That's very positive. And I always had confidence because of former Chief Justice McDonald's involvement, because he had a great reputation as a judge. He wasn't afraid to step out from behind the bench and, speak at times. And, so that always gave me some confidence that the process was going to unfold. The question I think many will still have is, why wait until now? I mean, these questions have been circulating in the public mind and among the family members. You know, why was that lack of clarity allowed to linger for maybe an extended period of time? And I don't know, but maybe there was some, discussions among the commissioners as to what that might mean. But certainly they came out with a clear decision today on it.
I'm somewhat buoyed by the fact that there have been adaptations made, including the names of the victims on the screen when they first came in. Something they said, it was suggested to us, and we thought that made sense. It was appropriate. So that this does feel like a process that's evolving, and that the former Chief Justice also said that trauma informed should not be a shield from testifying. And I think that is a very important point to be made, that he is asking for, and we will have the three first responding officers as part of this witness panel on the 28th when this resumes. Your thoughts on what that should bring us as far as some kind of illumination?
Well, they were very, they were the first ones into the community from the police perspective. They'll be able to tell us about that, what they were thinking, what they were feeling, the decisions they were making, what information they had. all of those things. So it's very important, and we'll be hearing that right away. Some of the other witnesses won't be until May or even later, perhaps, but we'll hear the story from the first three, and hearing them together in a panel, I think that's appropriate as well. We've had a panel of witnesses in the Desmond inquiry, and it can work quite well as because they were there together, so certainly they're going to have a common experience to relate.
I've also, as many have noted, was concerned that there would be that perception that this is not going to get to the truth. But there are some truths that will never be known. You know that from your experience, that some voices cannot be heard from. There was the comment though about the two folks from the United States, the couple, the Friends couple in Maine, where one of whom is, I believe, owner of a car dealership. He apparently has been interviewed by the FBI. Yeah. And that they're not really in a position that they can't legally subpoena witnesses in a different jurisdiction. What's your understanding of that, and how that may be important to this?
Well, they were among the last people to speak with the killer before he went on his rampage. So, to know what those conversations, what was the content of those conversations? I mean, that wasn't covered by the FBI interview, strangely. So we'll hopefully be able to hear about that. And then just, they were friends. What was their knowledge of the killer? It sounded like he was probably drinking that night. He sounded like he was a very bad drunk when he was drinking. How drunk was he? That sort of thing. I think those kind of details that they can add are important. And so hopefully they'll voluntarily cooperate with the commission. And if they don't, that's going to leave a big gap in the evidence, unfortunately.
And so far, this process, we've had a lot of legal wrangling, if that's appropriate to use that term, to hear from the lawyers representing families. And I want to be clear, this is no way disrespecting that process, but there are class action lawsuits involved. There is a vested interest, and the evidence that is presented here, my understanding is some of it may very well become part of a civil case in the future. With that preface, what's your thoughts on some of the questioning, some of the areas that the lawyers are asking for some clarity, and this idea that we need to be much more informed about the experts in the witness testimony?
It's an interesting dynamic in a way, because they have that civil case outstanding, and in some respects, the interests of the families are more geared towards that civil case, certainly the financial interests. But the interests of the public and, the true underlying interests are here in this inquiry. So hopefully if there's any dispute between those two interests, that doesn't manifest itself by, any behavior during the inquiry. The families in many ways are a proxy for us as the public to ask the questions that we would want to ask. So hopefully I think that, will continue to unfold in that manner. So that's an issue that could rear its head, but they've been pushing for the right answers. One of the things that came out today about the overnight, and the families are going to want to question this, is when could an emergency alert have been issued, or when maybe should it have been issued, and then what may have been the results. And we heard today that there were 3 witnesses in the Debert area that saw this mock police cruiser. Well, they didn't know it was a mock cruiser at the time. At 12:30 in the morning, 1 o'clock in the morning, around the business park in Debert. Well, had an alert been issued, in the hour or two prior, surely one of those witnesses would have contacted the authorities, and, that might have been the end of everything right there. So, the family from the civil case perspective are going to want to know those kinds of things, and, what deaths could have been prevented by different actions by the police.
Commission Chair McDonald has said he wants to hear from the officers to find out, as he points out, what they chose to do, what they did not do. And I think that is something you've touched on there, which is in hindsight, because if a stated goal is to prevent something like this from ever happening again, what lessons to be learned, what mistakes were made, those types of scenarios. But where I'm somewhat challenged is the narrative of conspiracy, and I know you've addressed in some ways how it would affect this process if it were to be revealed in some way that Gabriel Wardman had been working with police as an informant. I spoke with someone who was an informant who says none of what he's heard or witnessed would give him that conclusion. So just curious to your thoughts there.
Yeah, well, we certainly hope not, really. That, we hope that there's no conspiracy or cover up or anything of that nature. Because there's some questions outstanding, I think it needs to be explored to the satisfaction of the families, or, well, to the satisfaction of the reasonable person observing. It's, one doesn't think, I tend to think, I don't want to say incompetence. It's usually more incompetence than a conspiracy, right? So, or structures. In this case, I wonder, in the emergency alert specifically, whether the sort of hierarchical structure of the RCMP was itself an issue. Stuart Purcell at 11:16 is suggesting an emergency alert be issued, or is questioning it. Well, but then that had to go to the next level up, and so how long does it take to make a decision, rather than having perhaps the officer who's on the ground, who has the best understanding of the situation in a lot of ways, be able to make that decision themselves, particularly in a rural area where, it's difficult to explain what you're seeing over the radio to a supervisor who then has to make that decision. So those are the kinds of, I think those are the kind of answers that are going to emerge from this, rather than any kind of, conspiracy-minded issue.
And truly, as one statement from the officer who was first in charge, he wasn't even aware of the alert surface. That was not something that was common knowledge to him. So there are lessons to be learned. There's no question about that.
Yeah, that's right. I mean, on the alert website, an active shooter situation wasn't even one of the scenarios that was listed as, a potential use for it.
And my experience, I was involved with radio and television news directors for years, and the Amber Alert system in Nova Scotia has never, ever really been launched appropriately. And I don't know whether because it's provincial, municipal overlap, where the real stumbling blocks have been, but clearly that's a gap that I think the province closed a little bit with some of the changes that were announced before the last provincial election. All of this to say, we're still very in the very initial stages of this. We're hearing about testimony into May. So to that point, I think the chair is saying, there is a process. There will be 30 some foundational documents, and perhaps some of these questions will be answered then. Your thoughts, given again that this is going to be a months-long process.
Months-long process with an interim report due in May. Now, I'm involved in the Desmond inquiry, which is we're doing our closing submissions next month. And that's been on for, a few years now. Of course, there's been delays because of COVID and such, but, one could imagine something on the scale of the Mass Casualty Commission taking a much longer time. They're going to really have to work hard to get all of this evidence in and have a final report done by November. They can do it, but it's going to take a very concerted effort they have a large staff to help them. But there's going to be quite a few witnesses coming through and being heard from. So that's going to be an intensive process.
Yeah, absolutely. And I guess, again, to cap this off where we started, the interview that is expected maybe as early as this afternoon. We're not going to hear what comes of that for some time yet. But, how this does change perhaps the water and the beans, as they say.
It could change it a lot. Although here's an interesting thought is, I think it's interesting. Her return date is May 3rd. With restorative justice, I mean, the common procedure would be you are referred to restorative justice, you do something, you write an apology letter, take counseling, do community service, whatever the case may be, and then you come back and, assuming you've completed the process, the charge is withdrawn by the Crown. So technically, Ms. Banfield still has legal jeopardy until that happens in May. So I guess she'll, maybe she has some agreement that she'll cooperate on the presumption that process is going to unfold as it should. Mm-hmm. But she may still, under, an abundance of caution, wait until May 3rd before she does that because, the charges are still outstanding.
In that first argument from her lawyer about why it wouldn't be appropriate, he did raise the jeopardy issue. But I think I felt, and I don't know if anyone else, maybe I was wrong, but felt he was suggesting if that was gone, if that jeopardy was gone, she would be available. Sounds to me like there was a concentrated effort by the Crown and the members of this commission, and I don't know what. I'm not inferring that there was undue influence, because ultimately the goal was to have her to appear and to be sworn, give sworn testimony. So perhaps there was some type of arrangement that we may never know about.
If there was influence, you'd say, well, probably wasn't undue. I think the Crown was asked today if it went up to the Justice Minister, and that was denied. So it would have been within the Crown office. Although I think the head of the Crown Commission, Public Prosecution, said it was an individual Crown decision, which strikes me as that's bizarre. If that was the case, it really should have, to me, been something that was decided across the board with the three accused. There's two others, Mr. Brewster and Mr. Banfield as well. Mr. Banfield's already pled guilty. Of course, even after you've pled guilty, you can still be referred to restorative justice, but there was no discussion of that today.
Right. We're in for a bit of a break, a long wait until the next process, and then again, a time before we have that interim report and the final report. This is not over yet, but I'm feeling a little more confident. I'm sensing that folks are feeling a little more confident about the integrity and the transparency, and I think that's a huge credit to Mr. McDonald and the work that he's doing, and people can call me a supporter and a cheerleader if they want, but I wait for the evidence, and I'm seeing some evidence of that today.
Yeah, no, definitely. It was a pivotal day, important for all of those reasons. And so that's, it bodes well. And I hope the families are reassured by that, at least to some extent.
Adam Rogers, and your YouTube channel, what's it called?
It's the Rogers Brief, and I'm on Twitter at Adam Rogers NS. So I'll have a piece out today on today's proceedings, and do that every day of the proceedings. So I'll continue that.
Thank you so much for your time.
Thank you.